passed a law closing the Democratic Party primary, not the Republicans, the Democratic primary to blacks. No blacks could vote in the Democratic Party primary by state law. The Supreme Court shot that down. Right? It was patently discriminatory based on race. Okay? So the law was declared unconstitutional, whereupon the state of Texas turned around and said, okay, we're going to pass another law. And this law will give authority, under law, give authority to the Democratic Party committee to close its primaries to blacks, which it did. That issue was appealed to the Supreme Court of the United States, and again, the Supreme Court struck it down, struck down the state law. Okay? The next thing was that the state of Texas then said, all right, since the Supreme Court is striking down these laws, we are simply going to take matters into our own hands as the Democratic Party, and we will say that our primary is closed to blacks, okay? The Democratic Party committee made that rule, okay? That gets appealed to the Supreme Court, mid-1930s, 1935, and this time the Supreme Court, with, I think, some reluctance, said, well, you know what? That's okay. That's okay. Why? Because it isn't the state that is being discriminatory, it is a private organization. The Democratic Party, like all parties in our system, are private organizations. Okay? So, 8-1, the Supreme Court says it's a private organization, they can run their show the way they want to. If they want to exclude blacks, too bad, but it's all right constitutionally. They are a private organization. Okay, then we get, here's where the plot thickens. We come to 1944, a differently composed court, and the same issue comes back again. This is a case called Smith against Allwright. Same thing, the party closes the primaries to blacks. This time, the Supreme Court strikes it down and says, basically, here's the theory, you know, even though the party is technically a private club, it's a private organization, even so, what that party does when it holds primaries is really to participate in the general election process. Imagine it as a kind of stream of activity. And upstream you have the party primaries and they name the candidates, and then the stream goes along through the campaign season and you get down to the general election, which is very much under the control of government now, not the parties, government. And you finally get a winner who then takes office, okay? So the primaries are seen as part and parcel of the entire process, the whole flow of decision-making that culminates in the election of a public official, okay? And since the primaries are a part of that larger scheme of elections, the parties have to abide by the same rules that govern the general election, that govern government agencies, okay? So it's as if the party is acting as part of the government when it gets involved in primaries, okay? So that's the new theory, and it comes to be known as state action. What this private organization is doing, the Democratic Party, is participating in an activity which constitutes state action. If a private organization gets into state action, then it is subject to the various rules, constraints that would affect the government itself. Okay? Now, how does state action come about? Well, I've mentioned on your little sheet here, I hope, 3 ways in which this can be done. One is called, and these are court terms, not my own. One is called public function. That is, every once in a while you'll have a situation where a private entity, a private fire company, will wind up performing a public function. All right? Doing something which is normally the role of the government. When it does that, providing safety, for example, it engages in state action, says the court. And as such, it cannot discriminate. Okay? That's one form of state action. So a private entity is performing a public function. All right? A second version of this is entanglement. And this is where the private organization jumps into bed with the government. Right? They're working hand in glove, right next to each other, side by side. Right? Imagine, for example, we have some sort of a catastrophe, and the Red Cross comes in. And they're working right alongside of the government, doing many of the things that FEMA is doing or whatever, and they're working in perfect coordination. Right? Well, when that happens, then, says the government, you can't discriminate. You are acting as if you were part of the government activity. Right? Okay, and the third one then has to do with financial dependency. There are a lot of private organizations that feed at the public trough. I'll name one. Gettysburg College. The Supreme Court says that even though Gettysburg College is a private organization, it's chartered as a private organization, nevertheless, Gettysburg College feeds at the public trough. Gettysburg College gets government money. It gets it in the form of student aid. It gets it in the form of grants, research grants to faculty members. Sometimes it even gets it in the form of building buildings. My understanding is those beautiful dorms, right over here, Rice, Stein, and Hall, those magnificent structures were built with government money. Okay, so in a whole host of ways, we receive government money. And the court says at some point, we're not talking $5, we're talking about hundreds of thousands of dollars. At some point, says the court, if you want to take government money in substantial sums, you've got to play the game the way the government does. Right? If you don't, then don't accept any money. Right? If you want to discriminate, fine, but don't come looking for money. Okay? That's the way it is. Okay, so in these 3 ways, we have something called state action. This is a way that the court has fashioned, again, it's made this up, it's a way the court has fashioned to extend certain rights to nominally private organizations. Okay? Let me give you an example of a case that is, put on your judge's cap now. I hereby bequeath upon all of you the role of judge. All right? You can even be a Supreme Court justice. Okay? Leroy Urbis. Who's ever heard of Leroy Urbis? Who was he? You know?
He was the leader of Pennsylvania.
Absolutely. Yes. He was the Speaker of the State House of Representatives. A very powerful position. And it happened that Leroy Urbis, this is 1970, 71, Leroy Urbis was black. Okay? He was far and away the most powerful black person in the Commonwealth of Pennsylvania. So they're working late one night up in Harrisburg, and the legislature is finishing its work, and it gets to be, I think, literally 2 o'clock in the morning. And they finally gavel the thing to a close, and they're done. And some of the good old boys come up to Leroy and say, "Hey, Leroy, you know, we have earned the right to go out and have a few drinks." "Great," says Leroy. "Let's do that." Problem is, the bars are all closed. Except across the street in Harrisburg, right across the street, is a place called Moose Lodge, number 107. They're open. They're a private club. Let's go over there and have a few brews. Okay, so they take Leroy in hand, and across the street they go, and they belly up to the bar at the Moose Lodge, and they say, you know, fill 'em up, Jack. And the bartender looks at Leroy and recognizes him immediately, and he says, I'm sorry, Mr. Speaker, we cannot serve you.